Part 3 of 2K's trial brief. Petitioner obtained ex parte orders for the minor child's return on March 24, 2025, and the exchange was scheduled to occur on March 25, 2025 at 12 p.m. at the Central Los Angeles Police Department. Respondents' visits were ordered to be professionally monitored in Dallas County, Texas thereafter. Respondent failed to return minor child to petitioner at 12 p.m. on March 25, 2025. She did not show up at all to the police department and proceeded to withhold the minor child for hours inside the content creator house where she resided at the time, necessitating police involvement to secure the minor child's release to petitioner's custody. Respondent live-streamed the entire confrontation with the police while the minor child was present inside the house and also depicted on live stream. When the minor child was finally released to petitioner, respondent taunted petitioner in person and then sent her friends to follow petitioner and his family in their car. Respondent's then boyfriend, which was Itai, was subsequently arrested. Upon release from jail, respondent and her then boyfriend joked on social media about taking the minor child again. Concurrently, and the aforementioned custody of the visitation issues, respondent's abuse of petitioner had also intensified by March 2025. Petitioner filed a second request for a DVRO on March 27, 2025, which the court granted in part. Specifically, the court ordered respondent not to abuse petitioner. Respondent has basically ignored the existing DVTRO. Confusingly, when respondents' violations of the DVTRO have been brought to respondent's counsel's attention, she has suggested that the DVTRO issued on March 27, 2025 is not a normal restraining order because the court only issued orders not to abuse. Respondent appears to believe she is free to continue threatening, harassing, stalking, and disturbing petitioner's peace on social media because such conduct cannot constitute abuse. Petitioner's second brief, RE First Amendment issues, set forth various legal authorities which supports otherwise. Respondent is not absolved from wrongdoing simply because her abusive conduct is occurring via a social media account, as opposed to in-person contact or by sending communication to petitioner directly. Moreover, the parties specifically agreed, pursuant to the October 31st, 2024 stipulation order, to impose restraints on their abilities to engage in certain speech on their respective social media platforms. Thus, respondent is not only engaging in contact that is itself abusive, but her actions also violate the October 31st, 2024 stipulation and order. The malicious nature of respondent's conduct is further highlighted by the fact that when petitioner has sought and obtained relief from the court, respondent has intensified rather than recidified their behavior that led petitioner to seek relief in the first place. It is anticipated that respondent will claim petitioner has also spoken negatively about her on his social media platform, and as a result, petitioner cannot complain about respondent's behavior. Importantly, the only party who has repeatedly requested that the other party's conduct stop is the petitioner. The only party who is currently restrained by a temporary DVRO is the respondent. While there have been occasions after extended periods of ongoing online harassment by respondent in which petitioner finally attempts to defend himself, the evidence will show that the petitioner's limited commentary about respondent is mild in comparison to respondent's conduct and largely in self-defense. Without question, respondent's harassment has destroyed petitioner's mental and emotional calm to the point that petitioner has at times felt compelled to communicate a public response. However, there is a stark difference between petitioner's behavior and respondent's behavior, and only respondent's behavior rises to a level to constitute abuse. Respondent has unfortunately engaged in a public smear campaign against petitioner, making false accusation after false accusation about him without regard for the impact it has on petitioner's mental state or reputation. At this time, respondent also appears to be utilizing her recent court filings to advance a separate but equally false narrative. The respondent is unreasonably controlling, vindictive, and set on keeping respondent away from the minor child at any cost. Respondent has been making a spectacle of the judicial system, presumably to distract from the actual issues that are before the court. Respondent has gone so far as to alert social media in advance of her upcoming court filings, thereby putting the general public on notice that new documents will be available soon and ready for download. Those documents are subsequently disseminated across social media by users who purchase them from the court website, with other users commenting and rallying behind either party. To be clear, this discussion and or publicizing of court documents and details is not among the abusive conduct at issue in petitioner's DVRO request, although it has certainly exacerbated tensions between the parties. It is the respondent's violations of the court's order and nothing else that caused respondent's visitation to be professionally supervised. Meanwhile, it is the respondent's obsession with utilizing her social media presence to discuss, threaten, disparage, mock, and harass petitioner and his mother, which has left petitioner with no choice but to ask the court to intervene by issuing a permanent domestic violence restraining order against the respondent to help restore petitioner's peace and put a stop to respondent's abusive behavior. Number 4, legal authority. The legal authority which allows the court to issue the restraining orders requested by petitioner are set forth in 2 prior briefs. RE First Amendment issued, filed by petitioner in this case. In the event the court grants petitioner's request for a permanent DVRO, the presumptions against an award of sole and joint custody to respondent set forth in Family Code Section 3044 will apply. At this junction, respondent has not done anything to be able to rebut the Family Code Section 3044 presumptions. As mentioned here and above, respondent has failed to comply with the March 27, 2025 DVTRO. The number of violations are extensive, including one occasion where respondent's boyfriend, while live on social media, went in person to a hotel where petitioner was staying and searched for him while threatening to physically harm him. Respondent's boyfriend also recently threatened, also via social media, one of petitioner's witnesses who testified about respondent's physical aggression during the September 24th hearing on petitioner's prior DVRO request. The aforementioned incidents were precipitated by social media content of the respondent, including where she and her boyfriend are harassing and are threatening the petitioner together. A violation of the DVTRO in abuse itself, even a merely technical violation, which respondent's violations are not, supports the issuance of a permanent restraining order. That's the end of part 3. Go to part 4. Hopefully I can get it all in that time. If not, there will be a part 5, but they'll all be back to back. So go to part 4.